The day my father called me a liability in open court, I was wearing the same gray blazer I'd worn to my bar exam results appointment. I remember thinking as he said it into the microphone that the fabric still smelled faintly of the dry cleaners. Weird, the things your brain holds on to when everything else is falling apart. Or maybe not falling apart, maybe the opposite. Let me back up. My name is Vivian. I'm 31 years old. For most of my adult life, I was the quiet one. The one who sat at the end of the table at Thanksgiving and didn't argue when my father made a joke at my expense. The one who smiled when my older brother got the car for his birthday and I got a gift card to Barnes & Noble. The one who, when my father introduced me to his colleagues, said she's still figuring things out, and I just nodded and shook their hands and said it was nice to meet them. I was figuring things out. He just didn't know what. My father's name is Warren. He built a commercial real estate firm in Cincinnati from nothing. His words, always his words, from nothing, and he never let any of us forget it. My brother Marcus worked under him straight out of Ohio State. Marcus wore the same watch my father wore, laughed at the same jokes, called clients partner in the same easy way. I went to law school instead, which my father treated as a kind of polite betrayal. You could have joined the firm, he said, at my law school graduation dinner. Not congratulations, not I'm proud of you, just that. I passed the bar on my first attempt. I clerked for a federal judge in the Southern District of Ohio. I spent 4 years at a mid-size firm doing commercial litigation, the kind of work that's invisible until it suddenly saves a company from catastrophe. I was good at it. I was better than good. But in my father's world, if it didn't have his name on the letterhead, it didn't count. The real trouble started when my grandmother died. My grandmother, my father's mother, left her estate split 3 ways. My father, my aunt, and me. Not Marcus. Not my mother, who'd been out of the picture since I was 12. Just the 3 of us. My share was $340,000. My father received his share, my aunt received hers, and then, about 6 weeks after the will was probated, my father called me. He needed a short-term bridge loan, he said. The firm had a gap in a construction financing deal. It was temporary. 3 months, maybe 4. He'd pay me back with interest, 8%, he said, which was generous. He was my father. The money was just sitting there. Wasn't family what mattered? I was 38 days out from leaving my firm to start my own practice. I had a lease signed on a small office in Hyde Park. I had 1 client already committed. I had plans, but he was my father. I said yes. But I didn't say yes the way he expected. I didn't write him a check. I didn't do a handshake deal the way he was probably expecting, the way he'd done 100 transactions with people he golfed with on Sundays. I had a loan agreement drafted, proper terms, fixed interest rate, maturity date, collateral clause. The collateral he offered was a piece of commercial property the firm owned outright, a 3-story building on Vine Street that had been fully paid off for 11 years. I had a lien recorded with the county recorder's office. I had everything filed correctly. He signed without reading it carefully. I know he didn't read it carefully because when I handed him the pen, he made a comment about how I was so lawyer about everything like it was an insult, and I smiled and said, "That's the idea," and he laughed. He wasn't laughing later. The 3 months became 5. The 5 became 9. Every time I asked about repayment, there was a reason. The construction deal had delays. A tenant was disputing a lease. The market was soft. Warren's excuses were always delivered with this particular tone, slightly impatient, slightly injured, like my asking was the real problem in the situation. At month 11, I stopped asking and started watching. I pulled the public records on the Vine Street property. I checked the firm's court filings. Civil litigation is public record in Ohio, and I knew how to read a docket. I talked quietly to a contact at the county auditor's office who owed me a favor from a case 2 years prior. What I found was that my father's firm was not just having a rough patch. It was bleeding from multiple places simultaneously. 2 breach of contract suits, a mechanic's lien from a contractor, late property tax payments on 3 separate parcels, and Marcus, my brother Marcus, who wore a father's watch and laughed at his jokes, had apparently taken a separate, undisclosed draw from the firm's operating account to buy himself a vintage Corvette. I found out about that one from my cousin, who'd heard it from my aunt, who'd heard it at Christmas. I spent a long weekend in January building a file. Not an emotional file, a legal file. Every document, every date, every recorded instrument. I had my promissory note, my recorded lien, the chain of title on Vine Street. I had 11 months of non-payment calculated to the day. I had the interest accrued. I had the maturity date, which had passed 4 months earlier without a single dollar in repayment. On a Tuesday morning in February, I sent a formal demand letter via certified mail and email. I gave him 30 days to cure. He called me that night. He didn't start with hello. "What is this?" he said. Not a question. A statement of offense. I told him it was a demand letter. I told him the loan had matured. I told him I had a recorded lien and intended to enforce it. He told me I was embarrassing the family. He told me Marcus had nothing to do with this. He told me that family doesn't sue family. He told me that what I was doing was small and vindictive, and that I clearly didn't understand how business worked. I let him finish. Then I told him he had 30 days. He hung up. The 30 days passed. Nothing. I filed suit in the Hamilton County Court of Common Pleas. My father hired a litigation attorney named Philip. Expensive suit, silver cufflinks, the kind of guy who billboards on I-71. For the first 2 months of litigation, Philip's strategy seemed to be delay and volume, motions to extend deadlines, discovery requests so broad they bordered on harassment, a counterclaim alleging that the loan agreement was unconscionable because I had exploited a position of undue influence over my father as a licensed attorney. That counterclaim actually made me laugh out loud when I read it. I was 31 years old, 2 years into my own practice with a client roster that fit on one page. My father had been running a multi-million-dollar firm for 22 years. But sure, undue influence. The hearing date was set for a Thursday in April. Courtroom 4B, Judge Elaine Hargrove presiding. I knew of Judge Hargrove by reputation. She had been a commercial litigator herself before going to the bench. She had no patience for theatrics. I represented myself. I want to be clear that this is not something I generally recommend. I did it for 2 reasons. First, I knew this case better than any attorney I could have hired. Second, and I won't pretend otherwise, I wanted to be in that room as myself, not behind someone else's voice. My father arrived with Philip and with Marcus, who had apparently decided to attend as moral support. My father was wearing a suit I recognized, navy, faint pinstripe, the one he wore to closings. He looked, honestly, the way he always looked walking into a room, like he expected it to go his way. Philip opened with a motion to dismiss on procedural grounds. Judge Hargrove denied it in about 90 seconds without looking up from the brief. Then my father did something I genuinely did not expect. He stood up. Philip put a hand on his arm. My father shook it off. He addressed the court directly, which you don't do, which is not how proceedings work, and said, his voice carrying clearly through the whole room, that his daughter was mentally unstable, that she had always been emotionally fragile, that this lawsuit was not about a loan. It was about a disturbed young woman trying to destroy her own family because she had never dealt with her abandonment issues from when her mother left. Judge Hargrove looked up from her papers. The room went very quiet. I sat still. I had spent 11 months building a file, and I had spent 4 years in litigation, and I had spent my entire life in a family where the loudest voice usually won. I knew how to be still. "Mr. Bett." "Warren," Judge Hargrove said. She used my father's first name as his last name, which told me she'd read the file. "Are you represented by counsel?" Philip stood up immediately. "Your Honor, my client. I'm asking your client." My father said yes, he was represented, but he had things to say that his lawyer didn't understand. Judge Hargrove looked at him for a long moment. Then she said, "Sit down. You'll have your opportunity through proper procedure." My father sat. His jaw was tight. Philip tried to salvage it. His argument essentially was that the loan agreement should be voided because I had drafted it myself, creating an imbalance of sophistication between the parties. A real legal argument, actually, though a weak one on these facts. He submitted an affidavit from my father attesting that he hadn't understood the collateral clause. He argued that the lien should be subordinated to the firm's outstanding business debt. When it was my turn, I didn't raise my voice. I laid out the timeline. I introduced the promissory note executed by my father in his own handwriting. I introduced the recorded lien, filed the same week, county stamp, case number, all of it. I introduced 11 months of email communications in which I had made increasingly direct requests for repayment, and my father had responded with excuses and, at one point, a suggestion that I stop being so transactional. Then I introduced one more document. It was a title search on the Vine Street property, current, pulled 2 weeks before the hearing. My father's firm had taken out a second mortgage on Vine Street 8 months ago, 4 months after the loan matured, without notifying me. The mortgage was held by a private equity lender out of Columbus. It was subordinate to my lien, which had been recorded first, but it hadn't been disclosed in discovery. Philip had not produced it. I placed the document on the plaintiff's table. "Your Honor," I said, opposing counsel's client encumbered the collateral securing my lien after the loan had already matured, without disclosure. "I'd like to ask the court to take note of this for purposes of any sanctions inquiry." Philip's face did something complicated. My father turned to look at Philip. Philip did not look back. Judge Hargrove picked up the document. She read it. She set it down. She looked at my father, and then she looked at Philip, and then she said in a voice that was absolutely level, "Counsel, was this produced in discovery?" Philip said there may have been an oversight. Judge Hargrove said she'd like a full accounting of all encumbrances on the subject property submitted to the court within 5 business days. Then she turned to the counterclaim. She disposed of it in about 4 sentences. There was no evidence of undue influence. The agreement had been executed by an experienced businessman. The terms were documented and standard. The counterclaim was dismissed. She ruled in my favor on the primary claim. Judgment for the plaintiff. For me, in the amount of the original principal plus accrued interest at the agreed rate plus court costs. She noted for the record that the undisclosed second mortgage would be investigated further, and that my lien retained its senior position. My father stood up again. "This is not," he started. "Mr. Warren," Judge Hargrove said, and her voice didn't rise at all, "you will sit down, or I will hold you in contempt." He sat down. His face was a color I'd never seen on it before. Marcus, in the gallery, was looking at his phone. I gathered my documents. I clipped them back into my folder in the order I'd organized them. I didn't look at my father. Not because I was being dramatic about it. I just didn't need to. Outside the courtroom, in the corridor with the fluorescent lights and the bulletin board with the public notice postings, I stood by the window for a minute. The Ohio River was visible in the distance, gray and wide in April. I had a text from my paralegal asking how it went. I had a voicemail from my aunt, who I hadn't spoken to in 6 months. I didn't listen to it right away. What happened after that took several months to fully resolve. Philip withdrew from the case 2 weeks after the hearing, citing a conflict of interest he had apparently just discovered. My father retained new counsel and filed a notice of appeal, which went nowhere. The firm's financial situation, which had been deteriorating for longer than I'd understood, collapsed further over the spring. A judgment creditor from one of the breach of contract cases moved to enforce their judgment around the same time I moved to enforce mine. Because my lien was senior, recorded first, properly indexed, I was at the front of the line when the Vine Street property was ultimately sold. The sale took place in August. The proceeds were sufficient to cover my judgment in full, with a small remainder that went into the distribution waterfall for the other creditors. My father lost the Vine Street building. He lost 2 other firm assets in subsequent proceedings. The firm itself dissolved in October of that year. Marcus, from what my cousin tells me, moved to Charlotte to work for a property management company. My father sold his house in Indian Hill and moved to a condo in Loveland. I don't know if he's rebuilt. We haven't spoken. I want to be honest about something. I didn't enjoy most of this. I know that's not the satisfying thing to say. I didn't stand in that corridor after the hearing feeling triumphant. I felt tired in a way that had nothing to do with sleep. I felt the specific kind of sad that comes from being right about something you wished you'd been wrong about. My father wasn't a villain in some story. He was a man who had spent decades being the smartest person in his own room, and who genuinely could not conceive of a version of his daughter that was more capable than he'd decided she was. That's not evil. It's just a particular kind of blindness, and it's one of the saddest things I know. But I had lent him $340,000. I had filed the paperwork correctly. I had given him 30 days. I had done everything right, and when he stood up in that courtroom and called me unstable, called me fragile, tried to make the case that my grief over my mother leaving was the real reason any of this was happening, I sat still. Because I had a senior recorded lien on a fully paid off commercial property, and all the feelings in the world don't change what's in the county recorder's index. Judge Hargrove knew exactly who she was looking at when she looked at me. I think my father genuinely didn't, even then. My practice is doing well now. I have 6 clients, 2 of whom came to me specifically because they heard about the Hamilton County case. Apparently, it circulated in some local business circles in a way I hadn't expected. I have a second attorney joining me in the fall. I still have the office in Hyde Park, and I just signed a new lease. My grandmother's money is gone. It went back to me technically, but then it went into the firm's early operating costs and client acquisition. It dissolved into the work, which is what money is supposed to do. I still have the gray blazer. It doesn't smell like the dry cleaners anymore. It just smells like mine. People ask me sometimes if I regret lending my father the money. It's a reasonable question. $340,000 is not a small number. It came from my grandmother, who saved it over decades of careful living, and it went into a loan that turned into a lawsuit that turned into watching my father's firm dissolve piece by piece over the course of a single year. On paper, it sounds like something to regret. I don't, and I've thought carefully about why. What I've come to believe is that the outcome of a situation is almost never random. It's the accumulated result of every choice that came before it. Not in some mystical way, but in a very plain mechanical way. Warren made choices. He borrowed money without intending to repay it on the agreed terms. He signed a document he didn't read. He took on a second mortgage on collateral he'd already pledged without disclosing it. He stood up in a courtroom and tried to win through humiliation what he couldn't win through law. Every single one of those choices had a consequence, and the consequences stacked, and eventually the stack became too heavy to hold. That's not fate. That's arithmetic. What I keep coming back to is the moment he signed the loan agreement. He made a comment about how I was being so lawyer about everything. He meant it as a gentle put-down. The implication being that real family relationships don't need documentation, that asking for a proper agreement was somehow cold or suspicious. And I think he genuinely believed that. I think he believed that his version of how things worked, the handshake, the golf course deal, the assumption that his confidence was sufficient collateral, was just how the world operated. It isn't. It never was. He'd just been insulated from finding that out until he wasn't. That's the part that took me a while to sit with, honestly. Because Warren isn't unintelligent. He built something real over 22 years. But there's a particular kind of person who mistakes the fact that things have gone well for them as evidence that they understand why things go well. Those two things are not the same. Understanding why something works means you can rebuild it under different conditions. Assuming it'll keep working because it always has. That's just a loan you haven't been asked to repay yet. I kept quiet in that courtroom, not because I was afraid, and not because I was being strategic in some dramatic sense. I kept quiet because I had already done the work. The lien was filed. The documents were organized. The title search was current. There was nothing left to say that a piece of paper hadn't already said more precisely. I think that's the thing I'd want anyone going through something like this to hold on to. Not the vindication. The vindication is real, but it's also temporary. It fades. But the part that comes before it. The part where you do the work quietly, correctly, without an audience. Where you build something solid not because you're planning revenge, but because you respect yourself enough to do things right. That solidity is the only thing that actually holds when someone tests it. My father thought he knew who I was. He'd made up his mind about me a long time ago, and new information wasn't going to change that. Judge Hargrove read one file and understood exactly what she was looking at. The difference between those two people is the difference between looking and seeing. I'd spent my whole life hoping my father would eventually see me. I stopped hoping for that somewhere around month 9 of non-payment, and I started focusing on what I could actually control. That shift, from waiting to be recognized to simply being what you are, is the only thing I know for certain that works.